Legal, and I'm here with our founding attorney, Louis Landerholm, to talk about some pitfalls of representing yourself in a divorce. So, Louis, how are you doing today?
I'm doing great. How are you, Steve?
I'm doing well. This is a really interesting one because, we both know people who have decided to represent themselves, and we've seen the outcomes of their cases by not being advised on what to do and all of the decisions they have to go through. So I thought we'd talk today about some pitfalls that you see with a person representing themselves in a divorce, custody, support case, and the issues that kind of arise. It seems to me there's three kind of things. There's the legal, knowing the legal, there's the dealing with another attorney, and then there's the dealing with the court. So let's kind of start with knowing the legal. What are the issues that people run into just by not necessarily knowing the law?
Well, obviously, this isn't what people who are representing themselves do every day. And so, what I always tell people is the our job as attorneys, one of our main jobs, is that we know what happens in different courtrooms in front of different judges with different fact patterns because we represent hundreds and thousands of clients. And so what we do is we take bits and pieces from all of those cases, those experiences, those fact patterns, how judges applied the law to those fact patterns so that we can apply them to an individual client's case. That's the biggest part of the legal knowledge and the experience that comes into play versus somebody who doesn't do this and is handling their own case. The problem that you have is you go and you try to go to the internet. You talk to your friend or your couple of friends who they went and they've been through a divorce. You go and you try to read as much as you can. The issue with that is you're getting two, three, four different experiences and trying to apply that to your own case. Well, every case is so different. And so the law, there are intricacies, there are nuances, there are things that apply in one place that don't apply somewhere else. And when you're trying to do that on your own, you just have limited information and you don't really understand how the game is played and you don't understand how it applies to your individual fact pattern. And so you're either going to leave money on the table or you're going to be bringing things up in a case that the judge just doesn't frankly care about, or opening yourself up to other issues that you didn't want to open yourself up to. So there's as much as just understanding the way the law is going to apply to your facts and being able to then get that information out when you're in court.
And imagine that kind of flows through to you're going up generally against someone who does have an attorney, and that attorney may take advantage of the fact that you don't know as much about the law and kind of get you into a position that you don't want to be in. Because not everybody works with attorneys every day.
Oh, 100%. Yeah. Happens all the time, whether it's a taking advantage of or frankly just not knowing enough. You don't know what you don't know. So
Yeah.
you don't have the ability to fact check. You don't have the ability to say, is that right or is that wrong? Is there a different way of doing this? It may not be that there's, that somebody's getting taken advantage of. It may be just the mere fact that you don't know there's another way to do it. So you don't even know to counter with something, or that it could be tweaked, or it could be done better or differently. And so there's just an information and a knowledge gap when you're trying to handle a case on your own versus an attorney, for sure, or when you go to court.
Yeah. And the legal process itself can be difficult. Just working with, the courts, because there's timelines, there's things that are required. You can get tripped up in a million ways just getting through the system even before you would get to a trial.
Yes. all the time. I mean,
Well,
they're just, I mean, this stuff is complicated and there's only certain things you can do and it has to be done a certain way. And there's different timelines that have to be done and what you can use, what you can't use. And there's no substitute for time and experience, and there's no substitute for the knowledge. And so, the every county is a little bit different. They've got local rules that you have to figure out. You've got state rules. You've got some federal laws that come into play, and so just trying to figure all of that out is extremely complex and complicated. And then trying to navigate the judicial system by itself is just even just trying to how do I bump out my trial date? If my trial date isn't convenient, what do I do? What's the timeline? How many days? How do I, these things are just not, they're not exactly the most, they're not the easiest to figure out on your own. And so when somebody's trying to do that by themselves, there's a million things that could trip them up that then cause the case to go sideways.
yep, yep. And kind of they work together. What you're actually, let's say you're in the courtroom or you're in front of a judge. Um, that's a harrowing experience to say the least. People aren't used to that. And you can not ask for something. You can do the wrong thing. And that leads to that kind of other thing, which is, there are real consequences of getting it wrong. This isn't a case where you just get to go, oops, can I do it again in a lot of cases, is there?
No, especially in like for example in Oregon, we can't modify property distribution. So if you go and you have your day in court and you go and you have your trial and say you didn't know how to get a piece of evidence in, or you didn't then get to get a half of whatever account or half of what the true account value is, you lose your opportunity to go back and say, can I get that money that I left off the table? So that's just an example of something that you can't redo these things. There are certain things that can be modified later, but the importance of what those findings were from the judge, what the judge said in that first trial is going to impact, your case for, especially like in custody cases, for the remainder of your case. Custody is a good example. In Oregon, the judge can only order sole custody if the parties don't agree. Well, as a litigant, if you don't give the judge the right information and the judge rules for custody on the other side, it's extremely difficult to then modify custody later because there's a barrier to being able to talk about what's best for the kids. Washington handles it a little bit differently. It's more of a default on the joint custody side, but still there are times when custody is on the table. And if you don't handle that properly, then you lose your opportunity to bring up those facts, because then in a future modification, all of that information that occurred prior to that ruling is basically it's not relevant anymore because it should have been brought up at the time. And so trying to know all of that and making sure that you get the right evidence, that you could have the best evidence in the world, but it may not be admissible because you don't know the rules. And so trying to figure all that out, just it doesn't happen. It's not something that you can learn in a 2 month or a month period of time.
Yep, yep. And so someone comes in and they want to represent themselves or something, or you talk to someone who wants to represent themselves, but they don't. I mean, they just don't have enough money maybe to fully hire a lawyer. There are some things we can help with that, but it still isn't a full representation. But there are, if push comes to shove, some ways that we could help people who are in that kind of situation trying to represent themselves.
We can help to a limited extent. What I always hesitate to or help people understand is that we can't give a legal education in in a few sessions. Like it just doesn't work that way. Outside of, our attorneys going to law school or doing all of that, it's more of the years of practicing, the years of representing people, the years of, being in front of judges. And so we can't give all of that knowledge in a short period of time. There's just too much. And so, yes, we can help with minor things like how to get exhibits put together so that they're admissible. But there's exceptions to every rule. And so there are things that may come up in a specific case and a judge rules in a way that nobody could foresee. And that's just part of the deal, right? And if you don't know how to then how to bring up the exception to get a piece of evidence in, then you're stuck and it's not coming in. So it's the the actual representation in court is almost impossible to replicate. It's just a matter of trying to help people understand and be prepared. The biggest thing that we can help with are like in parenting plans or in an asset division, just being able to present a like a proposal so that you're speaking the same language as the judge. That's where we can be the most helpful with somebody who is self-representing, especially if there isn't another attorney on the side. Being able to walk in and say, Judge, this is what I want and why, so that the judge understands, what you're asking for. And I find that to be way more helpful than actually trying to teach somebody to represent themselves.
Yeah, yeah. We're about time to go, but we're running out of time. But I wanted to ask one more question about, kind of the idea of how, well, I'll put this, about, how it is so easy to just do one wrong thing. And it's part of that is that, you may think you really know the law, but this is a divorce and it's a very important thing emotionally, it'll financially, and a lot of reasons. And it's just not the time to try to save money.
Yeah, I mean, there's you only get one shot in most instances, right? And especially when kids are on the line and custody or a parenting schedule, making sure that you understand what's important, how to then if there's a substance abuse issue or whatever it may be, how to get that information to the court appropriately so that the court can actually use the information. Because just because this is the part that frustrates a lot of people with the legal system, is just because you have evidence doesn't mean that the judge gets to see it. And so, there's all these evidentiary rules. They're very complex. They're really intricate. They've been, made over, hundreds of years, essentially, on how to get a piece of evidence in. And there's certain things that will just be barred from being able to be used by the court, which is extremely frustrating. But at the same time, there's reasons for it, and there's historical reasons why. And that's why we have to know the rules so that we can get our evidence in so the judge can actually use it to determine the case. And so, I tell people all the time, it may cost, a few $1,000s up front to get the information and do it right. It's going to cost you 20 to 30, 40, 50,000 to go fix it later if something was messed up, because unraveling and trying to redo things is very expensive, and causes a lot of problems for a lot of people.
Right. Well, that was really, really interesting. Thank you, Louis, for sitting down to talk with us about, these real pitfalls of representing yourself in a divorce. Thanks for being here today, and I think it's really informative for people.
Yeah, you're welcome.
And thank you, everyone, for joining us today. If anyone has any further questions, please feel free to contact our firm. We can get you connected with an attorney who can help you. So stay safe.